have a full session. Okay. So we started with kindling the lights, lighting the candles. So that's what they. So point 3, the mitzvah is so important that a purpose must even appeal for funds in order to perform it.
I can't hear you.
In order to perform it, like as in the 4 cups of wine on Pesach, it's a similarity, and Chanukah, people must do anything they can to pay, to be able to purchase 2 candles and wine for 4 cups, and candles for Chanukah. The person who treats the mitzvah of Shabbos lights conscientiously will be amply rewarded. The mitzvah applies to both men and women, that is preferably carried out by the woman who performs the mitzvah on everyone's behalf. The Midrash writes that the woman extinguished the light of the world by partaking of the forbidden fruit in Gan Eden. She compensates for this by restoring the light on Sabbath Eve. It is appropriate for men to take an active part in the mitzvah, for example, by bringing the candlesticks, since he also withdrew light from the world in the sin of the golden calf. Now, single people should light candles because we haven't got wives yet. And Arthur's in a different position. His wife probably lights the candles. So it's nice to have candles, but if you don't, let's say Gavin or Damon, I'm sure you may have heard this before, or even Arthur. Let's say you don't have candles, you can actually switch on an electric light. And if you have them for the whole of Shabbos, say the bracha, then switch it on and have that as your Shabbos light, instead of your candles. You can do that as well. I don't know if you guys have heard of that.
And only single people?
No, I don't know if it applies to married. Let's say you don't have...
That's the super incentive.
But use that light if you don't have candles. Obviously, candles are...
It's interesting to know, yeah. I actually forgot this weekend to light candles. I left and then it was too late. I forgot. What happens when you forget? It happens once in a while, but what do you do?
Then you have to light extras, or you add extras, but check with the Rav maybe rather.
Yeah, you do. You add an extra candle for each time you've missed, eh?
Yeah, I'll have a bonfire.
Yeah, me too.
But then my question is, if you use the light as a candle, what happens when it's load shedding?
Well, it's beyond your control. You switch it on; it was on when you said the bracha. It goes off. It's not you. You didn't switch it on.
Your candles also go out.
Exactly. Good point. Exactly.
And it lasts an hour or 2 or 3 if you're using like tea light or something.
So Arthur, this has been a delightful discussion, eh?
Yeah.
It's the light of my life. What can I say?
Arthur appreciates my humor, Damon.
Yeah,
you're so sparky. It's like a flash.
All right. So that was good.
Send a new link.
No. We'll continue with this one and then we'll do another one.
So you can use an electric light. You can switch it on and make a bracha on that. I've heard it many times. I've done it. I actually did it a few weeks back because I went out for dinner. Especially, let's say, because you're supposed to see you get the benefit of seeing the flames. If you're going out for dinner, you're only going to be back many hours later. Like I went to a friend of mine. It was an hour walk. So by the time I got back at midnight, flames were candles were out. So that's why I needed the light anyway. So I used the electric light in my lounge area, and I said the bracha on that, so I could get the benefit of the bracha.
Go. So I want to ask you something. I'm going to Rabbi Landau on first night Pesach, so that's Saturday night. So I want to go to his shul, which means which is in on the other side in Waverley. So what's it? Also May of Savoy. And if I go that side, I won't be able to come back and light the candles. So how do I do it?
You need to have your side lights. Transfer the flame. You can, but when you come back from Rabbi, if you're leaving in the afternoon, you can't transfer a flame. But when you come back from Landau's place, hopefully the outside light.
Oh, on Pesach night at 11 o'clock.
Then you can light when you come back. Then light the candles, because unless you leave at nightfall, to land our space, then you can transfer the flame.
No, I'm going to go.
So keep your outside light.
Yeah, no, I am. I'm going to actually go buy today or tomorrow. I'm going to go through and buy. I don't have.
You really want to take this on if you've never taken it on at this particular juncture?
No. I have done it in the past. I have used the outside candle.
Okay.
I tried to use the outside candle for the other. Problem is that I'm not going to be here. I'm going that side. I'm going over at about 4 o'clock. I'm going to walk 4:30. I'm going to walk that side, and I'm going to Mincha and Ma'ariv there. So I'm not coming back. I'm going for supper that side. So I won't have an opportunity to light candles for Pesach first night. But what Kevin's saying is genius. Is that when I come back, I can still do it. So I'll
transfer the flame from the outside light.
Yes.
Yeah, with us, what we do is we use the outside light for our barbecue on the Yom Tov.
Yeah.
So
to light the flame.
That's how we light our flame.
You know where you can get that in the Talmud from a brisa.
Okay. Is it cheaper?
No, did you get the joke? I said that brisa.
Yes, I know. So is it cheaper?
Okay.
Okay.
Started.
By the way, Dan, I have to ask you a question. If you guys do the lights on, do you do the bracha and like Eskim stay on, or add the name in any way? It's a miracle the lights stay on over Shabbos. Guys, you got to come to Israel, and we don't have to joke about it.
Right, let's get started. I'm just going to do a bit of revision. Okay. So we were learning the second version of Rav Yossi Bachen in a statement. Rav Papa, in the name of Rav, teaches Rav Yossi's statement as having been said in regard to the first case of the Bryce as follows. If one enters the shop of a carpenter without permission and a chip of wood flies off and strikes him on the face and he dies, the carpenter is not liable. It was regarding this case of the Bryce that Rav Yossi Bachanina said he would be liable for 4 things if the victim is merely injured, and the brisa means that he is only not liable to exile if the victim dies. So the first case, both according to the Gemara and Rava's explanation of Rav Yossi Bachanina, is that if you do not have permission to enter, you're not paid out for injury. And the reason that it's different here is because Rashi said that basically he considers it grossly negligent since he was aware that the person had entered and should have been more careful when chopping the wood, meaning that he might not have given him express permission, but the very fact that he continued with dangerous equipment when he was aware of the person's presence is reason for liability. That's where we ended off. So what I'm going to do now is show you certain things of the Gemara, which gives you an idea that it's not just about somebody reading it off a screen, and it's a little bit more tricky than that.
Also, I want to just jump in for 1 second, Damon. Sorry. Yeah. What happens if the guy that goes in, right, doesn't get permission to go in and then goes in anyway?
So this is what we are talking about here, is that there are only 2 different stances on this. And the 2 stances are as follows. Either the shopkeeper, the carpenter was aware of his entry, even though he didn't give permission, in which case it's grossly negligent. And according to Rashi and Rav Papa's explanation of Rava, in that particular case, he's liable for the 4 things. What is it? Nezek Shalom, actual damage, paying medical expenses and convalescing, because that was gross negligence. He might not have voiced his permission, but he was aware that he was there. According to the first explanation of the Brisa, the first version, he didn't give permission when the guy called out, meaning he didn't think the guy would come downstairs. He said he didn't give permission. So that wasn't negligence. The person, out of their own volition, damaged themselves with stupidity, and therefore the carpenter is not liable. So the primary case of liability is the person that did not give permission aware of that person's presence coming downstairs? In other words, did he assume that the person would come downstairs? Or did he assume when he did not give permission that the guy would not come downstairs? So the one is saying, no, you can't come downstairs. Then he hears the person come downstairs and figures, you know what, stuff it. Nobody heard. You didn't hear what I said. I'm carrying on. That's grossly negligent. If he said you can't come downstairs, and because of the loudness of equipment, didn't hear the guy and carried on with the equipment, he's assuming the guy's not coming downstairs and listening to his instruction. They're two different levels of awareness. So Rav Papa prefers to explain, according to Rashi's version, or Rashi, who came later, is explaining Rav Papa's version, that there was a state of permission, even though there was a state of awareness, even though no permission was granted. Does that make sense? That's the only difference. So Gavin's question last time was, how do you prove it? Well, that's a completely different issue. At the moment, we're just discussing principles of awareness. All right, I want to share my screen. I'd like Arthur to read this. Arthur?
Yeah, I'm here. The Gemara remarks regarding these two versions. The one who teaches it in regard to the Varasa's last case holds that it certainly applies in regard to the Varasa's first case. But the one who teaches it in regard to Varasa's first case will say that it applies only to that case. But in regard to the Varasa's last case, the law would be that since the victim entered with permission, the carpenter is liable to exile.
Right, this is the next piece of the Gemara that I'm busy learning at the moment that we're going to deal with now. Now, I'd like to encourage any of you, if you can make head or tail of this. Because what I'm trying to show you is as follows, and I'll share my full page with you. Sometimes you read in the Gemara and you think, well, Damon's not doing such a difficult job. That fool is only just reading off the page. I'd like you to see if you can work out what it says here by just reading off the page. Because this is what I'm dealing with now, with you guys.
What was the Bryce's last case? For a start. And we can try, it might help us.
Okay, but just read it and tell me if it sounds as clear as mud to you. Just see if any of you can make head or tail of it. This is the next part.
At first glance, no idea what's going on.
Okay, so good. So why I'm showing you this is for a very particular reason.
I'd have to look at notes and how to find out what's happening there.
So if I show you my screen here, okay?
That's if they cover it.
Let me just share my screen. Okay, you read this? It says the Gemara remarks, so he would be liable for four things if the victim is merely injured, and the brisa means only that he's not liable to exile if the victim dies. So now we learn that Rav Papa in the name of Rava teaches also again this version where there's no permission granted, that he's still not liable to exile if the victim dies. Now if you read the next part, that's rather cryptic. It says the Gemara remarks regarding these two versions. The one who teaches it in regard to the Brisa's last case holds that it certainly applies in regard to the Brisa's first case. But the one who teaches it in regard to the Brisa's first case will say that it only applies to that case. But in regard to the Brisa's last case, the law would be that since the victim entered with permission, the carpenter is liable to exile. Now I encourage any of you to go ahead and teach this year. Because what I'm saying is sometimes when you read it, it's actually rather cryptic.
I would have to write this down in order to work it out. I'd have to write down, go back, see which case is the first one they're referring to, it's a big job to do this. So.
Yeah, so I'm just saying it's not just like reading off a screen. All right, so let's just examine this piece by piece, guys. We ended off by saying, according to Rav Papa's version of Rava, you're liable for four things if you didn't grant permission. Why? Because as Rashi said, he had an awareness that he came downstairs towards the carpenter's factory. In the first case, without permission, it was stated very clearly that he's not liable for physical damage because when he said you can't come down, he's assuming the guy's not going to come down. He's got loud equipment and maybe he didn't hear him. Okay, that's clear. So even in the first case, when he seems to have an awareness that the guy comes downstairs, he's still not liable to exile. Why is he not liable to exile? So this is a bit tricky to kind of work out, especially since he had an awareness. So then why is he liable for the full things? So we're going to deal with this. The first thing is, let's analyze the next part of the statement, because that gives a clue. The one who teaches it in regard to the Bryce's last case holds that it certainly applies to the Bryce's first case. So the first issue we're dealing with is, who's the one? Is it the Gemara explaining Rav Yossi Bar Chanina? Is it Rava explaining Rav Yossi Bar Chanina? Is it Rav Papa explaining Rava explaining Rav Yossi Bar Chanina?
Exactly.
Okay, that's the first thing that's rather cryptic. Second thing is, what is the last case? Says one who teaches it in regard to the Bryce's last case holds that it certainly applies in regard to the Bryce's first case. So let's discuss what the last case is. Last case is if the customer came down with permission of the carpenter. That's the last case, with permission. The first case is with no permission. That's the first case. Does that make sense? Fine. So what he's saying is, if in regard to the Bryce's last case, holds that it certainly applies in regard to the Bryce's first case. But so it's saying it has to be a principle that when it obligates you for liability in the last case, it certainly means you're liable in the first case. Okay, that's your first clue. Second clue. One who teaches it in regard to the Bryce's first case will say it only applies to that case. Okay, so then there's a separate opinion that said it only applies in the first case and not the last case. So again, the first statement is saying the one who teaches it in regard to the Bryce's last case holds it certainly applies in regard to the first case. Says, but the one who teaches in regard to the first case will say that it only applies to this case. It cannot be the same opinion, is it? Guys?
No, they're different cases.
Why? Because if you're saying, listen, the last case it applies, where he gave permission, he's liable, and then it will certainly apply in the first case that he's liable. It's very hard to believe that. Why? Because the last case, he gave permission. In the first case, he didn't give permission. So when would he be liable? In other words, if more so when you gave permission, you'd be liable, how would you also certainly be liable in the first case? That's the problem. Second statement. There are those that say, there's one that says it's liable only to the first case. Well, that's a problem, because if you're liable only to the first case is less stringent. It's less stringent. How do you know it's less stringent? He didn't give permission. So then you can say it only applies to that first case. So that's difficult to believe, that there's some sort of liability that only occurs in the first case where you didn't give permission, and now when you're being more harsh by giving permission and continuing with dangerous equipment, it would not apply to that case. So it seems kind of cryptic. Then there's a clue in the end, but it says, but in regard to the Bryce's last case, the law would be, since the victim entered with permission, the carpenter is liable to exile. And then we learned in a previous statement to this that even according to Rav Papa, in the first case where he didn't grant permission, he's not liable to exile if the victim dies. So let's just get rid of the cryptic nature right now. The first thing is we cannot be talking about damages. Okay, let me share my screen and show you why. Okay, that's your first clue to try and work out. Just read it again, guys. Can you see? Can anybody make head or tail of it? Not really. I can't hear anybody. Guys, do you have your mic on?
Yes. Damon?
Yeah, I'm listening. You didn't have your mic on before.
No, I haven't touched anything.
Okay, so listen, guys, firstly, it can't be talking about damages. Arthur, Kevin, why can't it be talking about damages? Let's go this here. The one who teaches it in regard to the Bryce's last case, which is you being granted permission by the carpenter, certainly hold that it applies to the first case. Okay, so if you're liable for damages in the last case where permission was granted, okay, the first case where no permission was granted, you wouldn't say you're certainly liable for damages in the first case where no permission is granted. What you could say is, even if you're going according to Rav Papa, it also applies. Certainly means even more so. Do you agree, guys? That's the first problem. Gavin,
sort of getting it.
Yeah. I'm hearing you. Carry on.
Okay, so what I'm saying is this. Well, the first thing we want to eliminate is this particular section is talking about damages. Because with regards to the last case where the carpenter gave permission, and we certainly hold that it applies to the Bryce's first case, meaning the last case where you gave permission, all opinions agree that you have to pay for the four things in terms of injury. And when it says it certainly applies in regard to the first case where there's no permission, it's not necessarily the case. Even according to Rav Papa, it also applies because of the awareness of the carpenter. But the word certainly applies means even more so. And it's not even more so in the first case. It's less. It might also apply, but it's not certainly. It's not more stringent. So the first thing there is that's a clue. We're not dealing with damages at the moment. We're dealing with exile. That's your first clue. But one who teaches it in regard to the Bryce's first case will say that it only applies to that case. Now, we can't be talking about damages because nobody, not even Rav Papa, would say that if you pay damages in the first case where no permission was granted, but because the carpenter was aware, that it only applies to that case. Obviously, all opinions agree that when you gave permission, that all opinions agree that you have to pay for the four things of damage. Does that make sense? So far, what this cryptic message teaches us is it's not dealing with damages. And the confirmation is, but in regard to the Bryce's last case, the law would be that since the victim entered with permission, the carpenter is liable to exile. Okay. So, Rav Papa's last case is even if you paid for the full things, because there was no permission granted, even though there was awareness, but you don't get exile. According to the second case, Rav Papa and all the opinions said permission was granted, and therefore the second opinion says you're liable to exile, but the first opinion says even though permission was granted, you're not liable to exile. These are the two different versions of the Gemara. Now, I don't want you to be confused just yet. That'll come. Just give me a second. Hang on, guys.
Yeah, it hasn't passed that stage. Don't panic.
Stage already. About 15, 20 minutes ago, I think, Arthur.
I think it was in Bava Kamma 2B or 2A.
Yeah, so Damon. So you say when you say damages, that's to the person that was injured.
Yes, absolutely. Certainly, the injured person doesn't pay the carpenter.
So you see,
the
carpenter doesn't get a scot-free even if no permission is granted. He still has to pay some form of damages.
According to the first version of the Brycer, he didn't grant permission, and therefore, even according to that version, he wasn't aware that the person entered without permission. He figured, why would the person enter without permission? And therefore, he's got loud equipment, and the person entered without permission.
Okay.
All right, I'm going to share my screen now, and this will add a little bit of clarity. Okay.
Yeah.
Right, first case. And I'm going to explain it much more carefully, but let's just go. The first case, the victim entered without permission. Carpenter is not liable to exile. Fine, that's clear. Okay. The last case, victim entered with permission, the carpenter is liable. Those are your two cases. Now, according to the first version of Rav Yossi Bar Chanina by the Gemara, he's not liable to the four things. Why? Because if he didn't grant permission, he didn't think the person would go downstairs. And he's not liable to exile because he's not aware that the person is there. He never granted permission. That's clear. According to the last case there, the victim entered with permission and the carpenter is liable. He's liable to the four things, but not to exile. Why is he not liable to exile? Because we learned it doesn't mimic the case Rav Yossi Bar Chanina said of the Gemara, where it's dealing with a private domain where permission was granted. In the case of the forest, it was a public domain where both had permission to be, so it didn't mirror the prototypical case. According to Rava's explanation, is that exile was too good for him. He didn't deserve the kapora, and he didn't deserve the protection against the family lynching him. Okay? Now, according to the second version of Rav Papa's explanation of Rava, he's liable to the four things. Why? Because even though he didn't grant permission, the carpenter, he was aware of the person's presence still coming downstairs. And why is he not liable to exile? Because it didn't enter the prototypical case. If you, in your own private domain, do not give permission to enter, it's not like a public park where you both have permission to be. Guy has no permission to be there. If he got injured, fine, you pay for the four things, but you're not liable for exile. It's your domain. You never gave him permission.
I want to ask you something.
Just one thing. Yet. Please, just sorry, but 1 minute. So as far as the last case is concerned, Rav Papa and Rava, you're certainly liable for the four things. Why? Because he entered with permission. There was full cognizance that the carpenter had, that the customer was there, and he's liable to exile. Why is he liable to exile? Very, very clearly, is because just like if you gave permission, you're aware of the person's presence, according to Rav Papa. So to in a forest, you're not the only one there, and therefore you can't do anything that could endanger other people. Okay. So I'm just giving, before we go through commentaries and explaining the previous thing, that's the difference. What were you going to ask, Gav?
Yeah, sorry, I'm just battling with one thing. You have covered it, but I didn't grasp it for some reason. I don't understand why if you let if you didn't give the first case, I don't understand why in the first case, if you didn't give the guy permission, why are you not liable for exile? Because exile is actually it's a win for you. It gives you an opportunity to do kapora. You've done nothing wrong.
Well, I'll tell you why.
I think even more so in the first case than in the second case.
Well, I'm trying to tell you why. Are you talking about the first? Because you're not liable both in the first version as well as the second version. Okay, where there was no permission. So there are two different reasons. We've got 1 minute left. I'm going to address this question quickly. Is that you're not liable to exile in the first case of the Gemara explaining Rav Yossi Bar Chanina, because the prototypical case is that you're dealing with a forest where both people have permission to be there. Both people have permission to be there, okay? And you're not dealing with somebody's private domain where there's no permission to be there. According to, and even Rava agrees with that, because no permission was granted. According to the second version, where there's awareness there, as far as that's concerned, the one opinion on that is that it still doesn't mimic the public domain, because it's your domain. You haven't given permission for him to be there. The fact that you're aware that he's there doesn't mean that he's entitled to be there. There is another opinion that said it would mimic the case of the forest prototypically, because you have an awareness that he's there. So there is an opinion that supports you. We're going to do another link.
Yeah.
All right. So listen, I wanted to tell you guys, it wasn't that I worked through this part of the Gemara. It's that Rashi worked through part of the Gemara. Without Rashi, I'd be lost. So I'm not claiming at all that you must know that I worked it out. I'm just going to share the screen and then explain to you Rashi's explanation from this cryptic verse. Okay. All right. So it says, The Gemara remarks regarding these two versions. The one who teaches it in regard to the Brice's last case holds that it certainly applies in regards to the first case, which means the first case even proves it more so. So obviously, guys, we cannot be talking about damages here, because the first case is when the person didn't give permission. There's not even more so you owe damage compared to when you did give permission. So we can't be talking about damages. We must be talking about exile. But the one who teaches it in regard to the Brice's first case will say that it only applies to that case. But in regard to the Brice's last case, the law would be that since the victim entered with permission, the carpenter is liable to exile. Okay? So this is what it means according to Rashi, which makes a lot of sense to me.
Yeah.
Is that the Gemara here is only referring to the second part of Rav Yossi Bachen in his reading. Okay, and it says he's not liable to exile. So the first version above, which has Rav Yossi speaking about the Brice's last case, in other words, where there was permission, he exempts the carpenter from exile even where the victim entered with permission. Okay? And we've learned these cases. How do we know we've learned these cases? Because if I share my screen with you, right? I'm just going to share my screen with you according to the first and second version of the Brisa. All right. So what Rashi is saying here is, look, whether you're learning the first case or the last case, if we're learning the first case of, let's just say where there was no permission, and then you're learning the last case where there is liability for permission. Can you see that when we learned the first version of Rav Yossi Bar Chanina, whether there was permission or no permission, there's no liability for exile, Kevin? This is going to deal with your question.
Yeah, I can see that on this.
Okay.
Did you draw this up yourself, or did you find this out?
No. I didn't draw this up. Thank God for Schottenstein.
It's very good, this.
Very good. So what it's saying is as follows. This is what Rashi is saying. That cryptic message that seemed to read that if it's in the last case, it's certainly even more so in the first case. We can't be talking about damages, because in the last case where you entered with permission, you can't be more liable for damages when you never granted permission. What he's saying is that if you're not liable to exile in the last case, according to the first version of Rav Yossi Bachen and how the Gemara started, where you had permission to be there, but the carpenter isn't even liable to exile in that case, the carpenter is not liable to exile in the first case where he never gave permission. That's what Rashi's saying. That's all he's saying. That's how he's explaining it. Does that make sense, Gav?
Yeah.
So he's saying, look, why aren't you granted permission in the last? Why aren't you? We've dealt this last time. Why in the last case, in the first version of the Brisa, isn't there liability for exile when the carpenter had permission? There's two answers.
I've got the one. Well, firstly, it's in a private domain, so that's number one.
And therefore,
so if it's in a private domain, then it doesn't follow that other case, which is in the forest, where the guy does get exiled because it's a public domain area.
Correct.
And
correct.
That anybody could be there at any point in time, and you need to be more vigilant because of that. In this particular, the guy's in his own domain, so he entered with. It's tricky that when he entered with permission, it's just not similar to the other case because you're in your private domain. The second answer, I can't think of right now. What's the second answer?
Okay, so the second answer is the same answer that you're not happy with it. So the Gemara explains Rav Yossi Bachen is saying, listen, the first answer, where the carpenter had permission in terms of not being liable for exile, is that you can't compare a case of a public domain where two people are allowed to be there compared to the case where even though the carpenter gave permission, it's still his domain. And therefore, a private domain is different to a public domain, because we learned the Mishnah opened up talking about private domain liability compared to public. So that's how the Gemara explained Rav Yossi bar Chanina. And Rava is as like you, Gavin. He's not happy with this. He's saying, but, it doesn't make sense. The reason it doesn't make sense is because, Arth, why doesn't it make sense? Arthur?
Yeah, I'm here. Sorry. The reason why the what?
Arthur, where were you?
The reason I said I'm here. I'm just saying back.
Okay, but I'm saying where were you? Like mine said.
Half asleep. I heard about 4 hours sleep. So.
Okay. So what we're saying as follows: is that the Gemara explains the first version of Rav Yossi bar Chanina as saying, look, if the carpenter gave permission for his customer to enter and he killed him because he didn't stop with the machinery, the Gemara says he's not liable to exile because it explains Rav Yossi bar Chanina because a private domain accident doesn't mimic a public domain accident of an unintentional killer. They're not the same prototypical cases. Okay? And Rava is not happy. Why do you think Rava would not be happy about it? We went through it twice.
Now, can I comment?
Art, do you have a thought?
Oh, no. At the moment, I got no thoughts going through my head.
Okay. Kevin?
I'm also tired, and I haven't been
Gav?
trying to focus today, but not so well.
Gav?
Gavin will get it.
I had something I think I might have forgotten. So he's not happy the same way I'm not happy. It doesn't. Why should it only be in a? It's the same concept. Conceptually, it's the same thing. It's recklessness. Why should it make a difference if it's in a public or a private domain? That would be my argument.
I think that's a valid question, and that's Rabba's question. Rabba said, listen, I understand in a case where there's no permission granted because you didn't think the person would be there, and even if you were aware that they were there, they had no right to be there. You did not say they could go there. The minute you give permission, you are acknowledging the person's presence. And therefore, in the public case where you're in a forest, you're acknowledging the fact that because anybody can be there, that there is the possibility of somebody being there. And since the possibility is that somebody is there, and then in the case of the forest, you're doing something, and if you accidentally kill them, would make you eligible for exile, when you gave permission, you should also be liable for exile. The reason you're not liable for exile is because exile is too good for you. Because in the case of a forest, there may be somebody there. There may be somebody there, Kevin. In a case where you gave permission, there is somebody there. And that's a different reason why exile is not granted, because that's bordering on the intentional. You knew somebody was there. You only get exile on the perhaps chance that somebody could be there because you're both entitled to be there. But where you know somebody's there, that's bordering on the intentional. And therefore, exile is too good for you. You don't even deserve the kapara nor the protection against the family trying to kill you. That's how he explains Rav Yossi bar Chanina. But Rav himself doesn't agree with his explanation of Rav Yossi bar Chanina, because he says if you're an accidental murderer bordering on the intentional, in other words, because you told the guy could come there and you are aware he's there, it's no longer perhaps, and therefore you are still entitled to exile. And he brought 2 cases. The first case he brought was with the lashes. The court had appointed agent to give lashes. And he said, listen, he gave a lash enough to kill the person, an extra lash, and he knew the person couldn't take a lash, and he's liable. Gemara said, no, he's not liable. He didn't count properly. It was an honest mistake. And then the answer is, well, he is liable because he could have counted with the judge. But that's not conclusively proved. Then we talk about the case of a stone in the public domain where he throws it in the public, and that's bordering on intentional. The guy said, no, he was dismantling his wall. Said he should have been careful, even though he was dismantling his wall. No, it was at night. There could still be people at night. No, he threw it in the trash. Were there people that used it as a public latrine, etc.? Do you understand what I'm saying? So in that particular case, even when there was permission granted, he's not liable to exile because it either doesn't fit, according to the Gemara's explanation of Rav Yossi Bar Chanina, the prototype of public versus private domain, or Rav's explanation of Rav Yossi Bar Chanina that he's not liable to exile because exile is too good for him, is that he's liable for almost intentional murder. The guy was there. But this answers your previous question, Gavin. And your question is, in the case where there was no permission granted, but he was aware that the person was there, according to Rashi, which is the second version of Rav Papa, explanation of Rava, why is he not liable to exile in that case? That was your question before the clip.
Yes, that's my question. I'm waiting for the answer.
Fine. So according to the one opinion, is that it still doesn't mimic the prototypical case. If you didn't give permission, if it's your domain, it gives you a certain amount of protection. And you're not liable. Are you with me? It's not a public domain. You have got certain rights in your own domain that if you don't grant permission, that it does offer you a certain amount of protection. It's your place. You don't have to. If you said to the guy you can't enter and he did, he's also responsible. That's one of the opinions. Does that make sense? Because he didn't get permission. The second explanation is that indeed he would be liable to exile because it in fact does mimic the case of the forest. How does it mimic the case of the forest? Well, very simply, it mimics the case of the forest in the sense that he didn't give permission, but he's aware the person is there. And in the forest, you're aware that other people could enter. And therefore, you're liable in the case of the forest on the perhaps chance that somebody could be there because it's not purely your domain. And here, you're aware the person is there because even if you didn't grant permission, you heard him. So in that particular case, there could be an argument for exile. And that would actually answer the Gemara's case, which would say, for example, the Gemara remarks, but one who teaches it in regard to the Bryce's last case, where he holds permission, certainly applies it in regards to the Bryce's first case. But one who teaches it in regards to the Bryce's first case will say it only applies to that case, which means it's a possibility, okay, that so for example, if it's a private domain, okay, so this was the original explanation, is that Rav Yossi Bar Chanina's rationale rather than Rav's explanation, because according to Rav's explanation of Rav Yossi's rationale, that the carpenter is not exiled for killing one who entered his shop and with permission, because the killing borders on the intentional. The Gemara could not state that the exemption certainly applies to the Bryce's first case, entry without permission. On the contrary, perhaps the carpenter is exempt from exile in the last case because his actions border on the intentional, but is liable to exile in the first case, entry without permission, where his actions border neither on the unavoidable nor on the intentional, according to Tosfot's. So we are saying here is, if you want to hold according to Rashi, that he didn't grant permission, but he was aware that the person's there. That's exactly the same type as the prototypical case of the forest, and he would be liable to exile. Does that make sense?
So does Rashi say he's liable to exile for the first case?
So even though the Gemara doesn't, there is an argument by Tosfot, it would seem, that it's possible that he would be liable to exile because he had an awareness the person was there, even though he didn't grant permission. Rashi just explains different points of view.
So I want to make a comment. If you're in the forest, I think whether you're aware that there's somebody there or not, if someone's there standing on the right of you or just behind you and your axe comes off, you're liable to exile. So so that forest example is not just if there's a chance that the guy's there. If you're actually aware the guy's there as well, full awareness, the guy's standing 50 meters away from you and you're reckless, you're still liable for exile. So I don't understand why it's not the same here.
Okay, I'll tell you why. Firstly, you've got a good point. Gavin's saying that there are two possible scenarios in the forest. And I think this is a very valid point. A, there's a chance that somebody could be there because it's a public domain and both have permission to be there. Or you go to the forest with your mate, he's eating a sandwich and you're going to go to the movies later and you decide to just prepare a bit of firewood for your supper tonight with him, and he doesn't get to see the movies and you don't get to see your family. And it didn't turn out so well. But you were fully aware that he was there, but you didn't choose your axe handle well. So in that case, you're fully aware somebody was there. You were just negligent, but because you weren't warned by Beis Din and it wasn't a purposeful murder and everything else, you don't get the death penalty. But so those are the two cases Gavin's describing. So he's saying in this case, where you didn't give permission, but you're aware that the guy came downstairs, how's that different? Why don't you deserve exile in that particular case? Is that what you're saying, Gavin?
Exactly what I'm saying.
Okay.
Because in both those examples that I gave you for the forest, whether he's not aware that someone's there, but there's a potential, and he is aware because it's his best mate sitting next to him or 50 meters away, he's liable to exile in both cases. So I don't understand why, he's not. But exactly what you said. Thank you.
So what you're dealing with here is you're dealing with a case where apparently it makes a distinction as far as domains are concerned. It brought this in this particular Mishnah because we talked about you damaging somebody from your private domain to a public, from the public to a private, and then from your private domain to another private domain. This whole Mishnah came out to discuss that there are legal differences between domains. And that even though in a case where you certainly weren't aware that somebody was there that you covered, in a case even where you were aware, it's your domain, you never gave them permission to be there. That's the distinct that's the distinct difference. There is that distinct difference. Then it just
I do see that. I do see that. Thank you.
The person has the slight. He came in. He said, "Can I come in?" And you said no. And you're carrying on working, and you hear a noise in the background. You think it could be him, or you think it could be maybe your blacksmith that works for you and works on tools or whatever, and you're carrying on, and something tonks him and he dies. You told him not to come down. He's also responsible. It's not like in a forest where you both are there, and you both are there either together with permission with each other, meaning that you both there as friends, or that there could be a person there and he has equal permission to be there. You've told him no, and therefore he bears a certain amount of responsibility. It's your private domain.
But now, can the family, in example one, can the family come after him because he's not entitled to exile? It's not negligence on his part. He didn't give the guy permission. So can the family come after him legally or not? I would think not.
I would think not. I have no idea, but I would think not. Not if you didn't grant permission.
Yes.
I would think not. All right, so let's go on and do a bit of coverage. I think those are good questions. All right. So let's just go on here. The Gemara has stated that according to the second version, the carpenter is liable to exile where the victim entered his shop with permission. The Gemara now challenges that this would create a contradiction between this brisa and another. Okay? But is the carpenter indeed liable to exile where the victim entered with permission? Why, it was apparently taught in the following brisa. If one enters the shop of a blacksmith and sparks flew from the hammer and the anvil struck him on the face and he died, this blacksmith is not liable to exile, even if the person had entered with permission. Thus, the brisa clearly exempts the blacksmith from exile, even where the victim entered with permission. All right, Kev, do you hear this case? Can I repeat it?
Yeah. I've got it.
More confused than when I started there. Now it sounds opposite to the other one.
Yes, what it's saying is there seems to be a contradiction because we learn a brisa, okay, that said, because I tell you what here, the second version that we learn is that the carpenter is liable to exile where the victim entered with permission. All right, let me share my chart again because maybe you guys missed something. Let me share it one more time. All right. There's a second version and a first version. Let's look at the last case. Victim entered with permission, carpenter is liable. What is he liable for? He's certainly liable for the 4 things if he damages, and he's liable to exile. In the first version of the Gemara, we learned that if carpenter gave him permission to enter, he's not liable for exile. We addressed this. In the second case, he is liable for exile. That's what Rav Papa said. Okay. So we're saying, why is he liable for exile? Because we're learning a different brisa here. There's a brisa we learned somewhere else in Shas, which basically states that if one enters the shop of a blacksmith, let's not take a carpenter, blacksmith that makes horses' shoes and metalwork, etc., and sparks flew from the hammer and an anvil and struck him on the face and he died, the blacksmith is not liable to exile. Okay? And it's even if the person entered with permission. So this brisa clearly exempts the blacksmith from exile, even where he gave the victim entry with permission. So it was saying, listen, we understand the first version of the brisa because it didn't contradict this other brisa in Shas. It said, like, listen, as a carpenter, you gave permission, it's still your domain, you're not going to get exile if you gave permission. According to the Gemara, it doesn't mimic the prototypical case of the forest. According to Rav Yossi Bar Chanina, exile is too good for him, and he doesn't deserve the protection of the family. He's bordering on intentional murder. Does that make sense, Gavin? That's why he doesn't get exile. So we're saying, but we're learning something. That's fine. Then there's no contradiction. Now Rav Papa brings Rav's case, and he said there's a different version. Apart from being liable for 4 things, if he didn't give permission because he had an awareness that he was there, when he did give permission and liable for 4 things, in that case where he gave permission, he's liable for exile. Why is he liable for exile? For exactly the same reason that Gavin said, is that forget about this case of a public domain and private. He knew the person was there. And it's exactly like Gavin said, that you're sitting with your mate, he's eating a sandwich, and you decide to do home improvements, and it kills him. Okay? So in that particular case, we're coming in right now, Kev. Gavin understands this case with Rav Papa and Rav very well, because he's saying, listen, you do get exile. We've even seen the Gemara that there are 2 cases in the forest. The one you don't know somebody's there, and the one you're sitting with your mate, and you enter together into the forest. So then you're entitled to exile. So Gavin's right. But then it seems to be a contradiction with this brisa with the blacksmith, because with the blacksmith, he gave the guy permission to come into his shop, tonked him, killed him, and now he's got an issue. And what's the issue? He's exempted from exile. Why? All right, Kev, what was your question?
Just something different. So if the customer wasn't given permission, it started walking down the stairs to the workshop, and then the carpenter heard him, then it's as if, so he's liable, it's as if he did give him permission.
No. So listen, Kevin brought up...
When's the answer you heard him? I don't, just thought of that.
Very good point. Now, in Shemayim, Gavin, they will hold this carpenter liable for being aware that the person was there. Maybe the carpenter had a bad attitude. Maybe he said, I told him he mustn't come. If he comes here, it's his problem. I can hear him go down the stairs. I'm just carrying on doing the work. Shemaim will hold him responsible for that. He won't get away with it. But an earthly court will not convict him when he didn't give permission, because the defense would be, I told him not to come downstairs. He had no permission to come downstairs. Therefore, the victim was responsible. He was partly responsible for his own demise. Does that make sense?
I think he's actually 100% responsible. In theory.
He might be, but the very fact that the other person was aware that he was there, Shemaim will say, listen, we knew you. We knew that you just kind of felt, well, if he does it, it's his problem. You knew that you could cost him a serious injury or his life. But there's a difference between what Shemaim holds responsible, because Hashem knows every person's thoughts, compared to what the earthly court methods of conviction are. Two different issues. So all we're saying is here, according to Rav Papa's explanation of Rava, where there was permission granted and now you're liable for exile, because it's exactly like Gavin said. There are two cases in the forest. One, you're chopping wood, you think there might be somebody there because two people have permission to be in a public domain. Many people do. Or you go there with your mate, he's sitting, he's eating sandwiches, you chopping wood, and dinner for that evening has been put on hold because he's dead. So in that particular case, you are fully aware he's there, just like when you've given permission. And therefore, in that case, in the forest, you're given exile. In this case, the very fact that you've given permission means that you've taken away your rights as a private property because you gave permission, So in other words, it's saying fine, but then there's a brisa with this blacksmith that seems to contradict that, because if a blacksmith, even if he gave permission and his client went downstairs and got killed by the anvil and hammer of the equipment, he's not liable for exile. So we're trying to reconcile these two contradictions between that brisa and this brisa. So the Gemara answers, with what case are we dealing with here in the second brisa? With the case in which the victim is the blacksmith's apprentice. This particular case is dealing with the blacksmith's apprentice. So what I was saying to you is, does the blacksmith's apprentice deserve to be killed? Just because he's ignoring maybe, why does he deserve to be killed? Why? What difference does it make if it's the blacksmith's apprentice, guys?
Because the blacksmith's apprentice should be more aware than a regular guy walking down the stairs.
Okay, that's
he's not working there.
That's an excellent point. Is that he's aware of how dangerous it is, and it's a bad idea to just walk downstairs. Excellent point. Yeah.
A blacksmith's apprentice shouldn't have to have permission to be there. He doesn't need special permission to be there. He works there.
Okay, that's an excellent point. Is that he doesn't need special permission to come downstairs because he works there. He's not a customer. So both Arthur and Kevin have got very, very good points. So then why firstly does it say he had entered with permission? Why bring that up? So the Gemara answers, the Brisa refers to where his master, the blacksmith, is pressuring him to leave, but he does not leave. So he was basically saying to him, listen, like you've done your job, I'm going to be working on very serious stuff here. It's time you finish your work day. This factory is going to become a dangerous area. Leave me to do my work. You've done your work. You got paid for the day. You can leave. So he told him to leave. Okay. So then there's a contradiction on the top, which I've just picked up now. It said, even if the person had entered with permission. I don't understand why it would mention here, because he's asking him to leave, to be honest. Anyway, the Gemara asks, and just because his master is pressuring him to leave, does he stand to be killed? Meaning, just because he never listened to his employer, does this mean a reason that he should be killed by the negligence of the employer, just because the employer asked him to leave? So the Gemara answers, the significance of the blacksmith pressurizing the apprentice to leave is that the blacksmith therefore thought that he had already left, and this is why the blacksmith is justified in not checking to see whether the apprentice was still there. Okay? So if so, then So what's the difference? In other words, he's asked him to leave, etc., and he's assumed he's left. So if so, the Brisa's ruling would appear even if the victim was someone else. Why would you specify that the victim was his apprentice? It doesn't matter who entered and who was instructed to leave. So let's say that the blacksmith would not be subject to exile since he has the right to assume that the person has already obeyed his instructions to leave. So what the Gemara is saying is, listen, why are you using the case of the blacksmith's apprentice? If you say to somebody, I'm closing shop now, please leave, and you're assuming they left, what difference does it make if it's your apprentice or not? Any idea?
Maybe I've got an idea, but I'm sure it's wrong. I'm sure it's not the right one, but I'll give it a shot. Is that The apprentice left his bag behind. He was going back to fetch it.
Okay, I think pretty much that's a good idea, to be honest, is that he might have...
Because the third-party person wouldn't come back. They would just leave. Whereby an apprentice, if he left something behind, even if he's asked to leave, he understands that, but he's going back to fetch something he left.
Gab, I think you must have a better memory than me, because you don't know how many times I've left my car keys and wallets at retail shops, and I'm halfway to the parking lot and realize I've left my keys there.
I do it with my phone, and I do it with everything. I do it simple as well.
Exactly. So that's not a reason. The blacksmith, anybody can leave their stuff behind. So
I see what you mean.
Reason. Someone else does not feel the fear of his master, whereas this apprentice feels the fear of his master. Meaning when your employer gives you an instruction to say, I want you to leave and not come back to the office today, you wouldn't take it as seriously if you're the one paying the blacksmith for services compared to if you were being paid by the blacksmith. You're more likely to listen to your boss than if the person that's doing your job, you're paying him for the service. So that's the reason. Okay. We're not going to go to the third version today. I think I've put you guys through enough. Does it make sense so far?
Very good.
Yeah, getting it slowly.